right, well, can everybody hear me? All right, good morning. So I heard our keynote speaker yesterday talk about that, wearing the uniform of what your clients should expect is an important part of what you do. This is my uniform. So I wore it today so you can get a sense of it, and I feel comfortable in my uniform when I do these lectures. So we're going to take a little trip away from science. I heard Mike Nelson talking about, performance and metabolic response. We're going to kind of get into law a little bit. From a practical standpoint, the idea here is to talk about what every personal trainer should know about the law. And the idea here is to give you, at least for those who may not have thought about the consequences of certain types of activities or certain risks you may take in training people, to kind of make you aware of them and hopefully prevent bad stuff from happening. So you could see there, you got the lawyer zone. There's like sharks swimming in that water. Nobody wants to go into shark-infested water, right? You want to stay away from that. So how do we do that? How do we stay out of that lawyer zone? How do we protect ourselves, protect our reputation, and protect our clients? So just by way of background, a little bit about my professional journey. So I was a prosecutor, went into private practice back in 1990. That was the year that Congress criminalized the possession of anabolic steroids. That really launched a lot of my business. I've represented probably more people involved in performance-enhancing drug matters than any other lawyer, certainly, and maybe most other lawyers combined, whether it's professional bodybuilders or other athletes either accused of doping, accused of using performance-enhancing drugs in a sport, or in many cases possessing or selling or importing illegally performance-enhancing drugs. I've also, was a competitive bodybuilder myself. I'm CSCS. I ran a personal training business for a while myself. But through the years, I've essentially been the go-to guy when personal trainers, dietitians, doctors who are involved in prescribing anabolic steroids, athletes have issues, questions, problems. I'm sort of the guy who's gotten called, so I have a lot of thoughts and information on that, and hopefully if you have any questions, I can answer them too. In the late 90s, to kind of bridge that gap between the performance-enhancing drug community and the academic community and the legal community and the medical community, I put up a website called Steroid Law. That's still there today. If you have questions about performance-enhancing drugs, that's a good place to go. I published a book a number of years ago called Legal Muscle, which was sort of everything anybody ever wanted to know about performance drugs from a medical, legal, social, sports performance position. Kind of was the impetus for a movie. How many people have seen Bigger, Stronger, Faster, the film? Okay. So, after that, Chris Bell, the director of the movie, had liked my book, Legal Muscle, and before he even started the movie, he came and we sat down and we talked a lot about it, and we kind of constructed that movie together, and that was just a great experience. I'm good friends with him and his family since, and we wound up shopping the movie and ultimately premiering the movie at Sundance Film Festival back in 2009, which was a great experience. I write a column in Muscular Development magazine, basically on where health and fitness issues intersect with law, culture, policy, everything from dietary supplement issues to whether a smoking ban in parks is good or bad, lots of issues like that. A lot of my clientele are in the supplement and particularly the sports nutrition community. If you have questions about dietary supplement issues from a legal perspective, I have a website at supplementcounsel.com, and that should give you some good answers. So it's been a great ride for me. I met a lot of very interesting people through my legal practice. We represented Sylvester Stallone's nutrition company when he had it for a while, when he was kind of on his comeback from some obscurity, and before the Rocky Balboa movie really came back and brought him back, and then the Expendables and such. I've had the opportunity to sit down with, it was actually before he was governor, Governor Schwarzenegger, in his Santa Monica office and talk bodybuilding. So for me, it was just a dream come true for a kid who's, former competitive bodybuilder, grew up living, sleeping, breathing, eating, bodybuilding, to spend a day with him. The first time I met him was in 2002 at the Arnold. How many people have been to the Arnold Classic in Columbus? So the first time I met him, they introduced me to him, and I do a little impression of him, and I figured, you know, I feel like I know the guy after all these years, and so, you know, I walk up and they said, Rick Collins, this is Arnold Schwarzenegger, and I put up my hand and I said, it's super fantastic to meet you. And he's like, oh, you do an impression of me? I'm like, I do, yeah, you're crazy. And we went back and forth. It's just a great guy, a great experience, and a lot of fun. So, lawyers, what do? We always do disclaimers, right? So what I'm going to say is not legal advice. I'm not creating an attorney-client relationship with anybody. These are my personal views on the law. All right. You should never assume that people know what to do in the gym. They can have some very interesting ways of doing things. And not everything always goes right in a gym. Sometimes things go wrong, or even horribly wrong from time to time, whether that's the fault of the trainer or the fault of the gym for maintaining equipment. Who knows? It can depend, or sometimes it's the fault of the person who's doing it, but bad things can happen. Also, sometimes people just don't know what they're doing in the gym, and I'm sure that everybody here has seen people in the gym doing things that I can't even figure out why they're doing it, but they're doing it, and sometimes, you know, it doesn't really go the way I guess that they had planned, unless that's actually what he meant to do by doing that. So, from your perspective, you know, you want to protect yourselves, right? And particularly, I was just in Canada and I gave a lecture, similar lecture to this in Canada, where it's a much less litigious society. There's a lot fewer lawsuits in Canada. It's just a mentality, I think, that you know, something goes wrong in the gym, maybe, you know, you get hurt even though you have a personal trainer, and, you know, maybe you break something, whatever. I think the idea is, you know, it was an accident. Accidents happen, move on, get it fixed. In the United States, you know how it is, you know, lawsuit is filed immediately, trainer gets sued, you sue the maker of the equipment, you sue the gym, you sue the manager of the gym who hired the trainer and failed to supervise him. You sue anybody who was standing around and didn't help you in time and could have saved. So that's sort of the society we live in. You can blame lawyers for that. I think that's part of the problem. I think also the response to fear of litigation has just, you know, changed the way people do things and has encouraged people to sue. So in terms of protecting yourself, I would assume that if you work for a gym, there's some sort of liability waiver that is institutionally provided so that everybody waives liability in a written form that's signed, a release of liability. If you're on your own, I'm hoping that everybody uses some sort of form that at least offers some protection. We'll talk about how it even varies state by state, what protection there is. But state law governs it. You need something in writing so that the client understands that things can go wrong in a gym and that they're waiving your liability for things that could go wrong that may not even be your fault. Now, obviously, if you're going to do a release and the client speaks Spanish, you got a problem if the release is in English, and vice versa. It has to be in legible font. If you've got a 14-year-old client, that's not going to be an enforceable contract, right? You want to have a parent sign. You can only ask for release of general negligence, not for intentional torts or gross negligence. What does that mean? Well, you can't put in the release, I waive all liability, including if you punch me in the face or kick me in the buttocks, right? Because that's an intentional tort. You can't waive gross negligence, which is like the highest form of negligence. If there are things in the release that are unenforceable, so for example, you can't punch me in the face, that can either, depending on the state, make that provision get thrown out or make the entire release get thrown out. So, and the release must be read, understood, and knowingly waived. So, now, if you have a release, does that mean you can't be sued? Anybody? No. People can sue for anything. So the release is just some level of protection, but something goes wrong, somebody tears a pec and you're there and, you can be sued. So what about insurance? Well, if you're not covered under an institutional policy of where you work, that release is not going to prevent you from needing insurance. In fact, if you get sued, you're going to want to have an insurance company handle that claim and settle that claim and protect you in that. So, and many insurance companies will want to see or give you a release that they want so that they can minimize their obligations. There have been some court cases on what waivers will not hold up. There was a court case that you can see there where the disclaimer, the waiver of liability, was written so tiny that people couldn't even read it. No, court said that's no good, not having all the essential terms. In some states, in New York, for example, there's a specific statute that says that a gym can't be released from negligence as a matter of public policy. So every state is different. Some states will always enforce waivers of liability. Some states subject them to a very high level of scrutiny, and you'll have all of these slides are available on your app. In some states, they won't enforce. In some states, there's inconsistent holdings. It really varies state by state, so you want to make sure that you understand the implications of release in your state. The types of waivers that will hold up in court have explicit language in them. This is just an example of one type of release that was, in fact, in a particular court case, found to be okay and held up in court on the case that's cited at the bottom there. So you want to use something that you think is, and that will cover all the sorts of things that are covered there in terms of damages, and make it clear that the client is actually waiving all causes of action, active or passive negligence. Now there is, yes?
Do you encourage all of your clients to bold specific line items like you're doing in this slide to emphasize?
Yeah. I think a court will definitely look at a waiver that has bolded terms to really let the client know exactly what he is waiving in a favorable way, in the same way that kind of burying it somewhere or putting it on the back of the form or writing it sideways on the form or in very small font. The court's going to have a problem with that. So now there is a defense certainly of assumption of the risk. And the idea there is that some activity is foreseeable to lead to an injury, and it's inherently involved. So you've got some examples there in bobsledding and racquetball, where, for example, where an experienced racquetball player chooses to play on a court that you could see is wet. The idea is he's assumed that risk. It's so obvious that he made that choice. So there was a mountain bike case where the issue is in mountain biking it's foreseeable that you may fall off the bike. That's part of the risk that you assume when you're mountain biking. It's not foreseeable that the mountain bike company would fail to make sure the brakes worked so that when you go to stop you don't. So what's foreseeable is something that can be an assumption of the risk defense. What's not foreseeable, the brake's not working, would not be. So, what types of lawsuits happen to trainers? What sorts of things would trigger a lawsuit and put you in that sort of shark zone? Well, one is not doing the right health screening. And I'm assuming that everybody does a detailed health screening, so before you start training somebody, you know what their limitations are, you know what their medical history is. So not asking, you ever have any cardiac problems? What sort of surgeries have you had can be a problem. Because obviously if you know that, you might not have had that client do certain exercises. Negligent health and fitness prescription. You may believe that a particular type of training is what's best for this client, but it might be so far out of the scope of what is accepted that in and of itself can be negligence on your part. negligent instruction and supervision. I'm going to give you an example of that in a minute. Obviously, there are trainers who will be sued for sexual harassment claims. Sometimes it can happen during spotting where a client says, the trainer's hands went where they should not have gone and it was not justified that the trainer would have touched me there in the process of spotting me on a squat or something along those lines. And then, of course, negligent maintenance of the facility or equipment itself. So, for example, let's say the lat pull-down machine has a cable up by the pulley that's frayed, okay? And it looks, we've all seen gyms where that, it starts to get a little messy and there's those little pieces of wire and you can see it's still there, but it looks like it's ready to go. Well, it may very well be that the gym is negligent for not having fixed that cable. But you're the trainer, and you put that client on that lat pull-down machine, and you tell him or her to grab that pulley, and it snaps, and there's an injury. Let's say it's front pull-downs, and you know where that bar's going to go if that cable snaps. You saw or should have seen that cable was frayed. Well, it's not just the gym that's on the hook, right? So, few examples. So just to kind of sensitize you to what sort of cases have been brought in the past. So you have a 46-year-old inactive, overweight male who suffers a heart attack after the very first training session, 60-minute training session. Here you have a court that holds that trainer negligent. Why? Because that trainer didn't properly assess the client's fitness level before putting him through a very tough training session that ended with a heart attack. So here you have another strenuous first training session. As you see, some of these are out of the very first training session. So, and you have a client that gets diagnosed with rhabdo and hospitalized and suffers a permanent disabling loss of muscle tissue and renal failure. The court holds trainer was negligent in, again, failing to investigate the client's health history and physical ability before deciding what is the appropriate training methodologies for this particular client. Here you had a $75,000 award. So here's a trainer who says, okay, here's what I want you to do. I want you to do burpees and deadlifts. That's what I'm going to have you do. Burpees and deadlifts is what we got you doing. And unfortunately, the client told, hey, listen, I've had back surgery, just FYI. Yeah, okay, let's do those burpees and deadlifts anyway. Well, it didn't end well for the client at all, and 2 surgeries were required. You had pain and disability for the rest of the life. Almost $1 million settlement in that case. So $1 million award for that client. You don't want to be on the receiving end of any of these things. Here's a woman, high blood pressure, 37 years old, high blood pressure. Trainer says, I got a great idea how you're going to lose some weight. We're going to give you lots of ephedra. Give you some ephedra. How does that sound? Great. Well, it didn't end well there either. There was a brain hemorrhage. Now you're up to $1.75 million in damages that were awarded against both the trainer and the gym. Now here's a good one. Woman says, listen, I've lived a very sedentary life. I don't really, walking for me is about as, beyond my capacity at this point. Trainer says, okay, well, come on over here. This is a treadmill. Woman's like, well, a treadmill? Probably never. What is this thing? It's a treadmill. Oh, okay. Well, okay, puts her on the treadmill, sets it for 3.5, and then maybe goes to, get a latte or get a cell phone that's over in the shoulder area, whatever it is, and somehow this woman on the treadmill begins slipping back until she falls off the treadmill and fractures her ankle. What happens? Court says negligence. Court finds for the woman and says, you can't just leave the woman on the treadmill. If she says she's sedentary, she's never been on a treadmill before, you got to tell her how to actually work the treadmill. How do I stop this treadmill? Because He, according to the court, failed to give her any instructions on the control panel of a treadmill. So let's do a little hypothetical. Let's say you're training a new client. Client doesn't tell you about any health problems, and you ask, any prior surgeries? No, high blood pressure, heart issues? No, I'm great, okay, fine, great. So now you put the client on a basic weight training program. For whatever reason, you decide you're gonna do some shoulder presses for delts, and you're kind of behind her, she's sitting in the chair, and you notice a scar on the back of her neck that looks like a surgical scar. Now, she's told you she's never had any surgeries. Well, you know what? She says she didn't have surgeries. I don't want to embarrass the woman, none of my business. And now suddenly things don't go well. She yells out in pain, and of course find out she had had cervical spine surgery, and the presses overhead caused the bone fusion to break. She didn't tell you, but you didn't ask. Who's at fault there? Anybody have any ideas? Who would be in fault in that position? Yeah, both. Yeah, sometimes it's not one person's fault or the other person's fault. It's everybody kind of contributes to the problem. And the law, depending state by state, yeah, Brad.
How would you be able to show that the trainer actually saw the scar?
There could be proof issues, certainly, but let's assume for the hypothetical that you did, you knew, and what is your obligation under those terms? So states look at these issues, and in some states it's what's called pure contributory negligence, and that means that if she is at all to blame, she loses. So it's a straightforward, even if it's 1% blame, in some states, not many, but in some states, you're off the hook if she's at all to blame. Now, she may say, I did tell him about the injury, and he just didn't write it down. There's always going to be issues of credibility and issues of proof. I didn't see it, she's lying. No, he's lying, but aside from that, pure contributory negligence, you win. Yes?
If it's on the release form and they don't put it, because we see them kind of thing. You read the release, there's nothing on there. You see scars everywhere. Is that negligence on their part, I would think, because they...
Could be both. Could be negligence on both parts.
You left this blank. You sure there's nothing? No, there's nothing. You know what I mean?
Right, yeah. And obviously you can only be held accountable for what you could visibly see either. And the law has sort of a reasonable person standard in most negligence issues, so it's what would a reasonable person do under these circumstances. A reasonable person, probably if you see a scar on the back of the neck and you've got the person doing exercises that might affect the cervical area, a reasonable person would say, hey, wait a minute, let's just put that bar back there. You told me you had no surgeries. I'm looking at, a scar on the back of your neck. Can we talk about that? Probably what a reasonable person would do. Not probably, a reasonable person wouldn't make a client, let's take off all of your clothes, I want to examine your entire body for any scars anywhere to make sure that you're not lying to me about your past surgical history. Yes?
On your HHQ, if you have yes, no for all of those, if you have any prior surgery, they got to check no.
Right. That helps enormously. That prevents sort of the word against word that, oh, you didn't ask me. Oh, I did ask you because I've got a form that shows that you said no. Now, so maybe it's in a pure contributory negligence state, you win. That's the end of it. But not every state works that way, because in some states they do what is essentially comparative fault, and that means kind of weighing, okay, maybe she was 80% at fault for not writing in there or telling you or disclosing it either orally or in writing, but you're also at fault because you should have seen that scar. You did see, and even if you say I didn't see the scar, maybe she was wearing a t-shirt that any reasonable person in your position would have seen the scar, notwithstanding your claim that you didn't. So in some states, it is an apportionment of fault, and that is essentially how a case is settled for an award. You're 30% at fault, you'll owe 30% of what the injury is. In other states, it's a little bit modified so that if she's more than 50%, sort of right on the line. If she's more than the 50%, she can't recover against you. If she's less than the 50%, then she can recover to the proportion of your fault. Does that make sense? So it depends state, and that is actually most states, so it depends by state, wherever you are, and these notes are all available to you. So let's take a case where you're a trainer, college football team, a student walks to the sidelines during a game, says he got kicked in the head, and then collapses. You help him up. You notice kind of like a weird thing going on with the left side of his face. You see some unequal pupil dilation. You see unbalanced body movements. You do the smart thing, right? You send him to the hospital. Send him right to the hospital. That's a good thing. He gets medically cleared, but you don't tell the hospital about those kind of weird symptoms, about the palsy on the face and the dilated pupils. You don't tell that to the doctor. A month later, student collapses. He's diagnosed with severe neurological problems resulting from a concussion when he got kicked in the head on the sidelines. Permanently loses control of one side of the body, suffers seizures. Are you at fault even though he was medically cleared? Even though he was medically cleared? Well, yeah, that court held that he was, and that's an actual case where the athletic trainer did not report those symptoms, so the doctor didn't know about those symptoms when he cleared him. So obviously, you know, just sending him to the hospital without enough information is not necessarily going to absolve you from liability. Here's another hypothetical. Let's say that you have a client who loses a lot of weight. She's down to about 95 pounds, and she says, look at me, I'm still so fat. You can see I'm like a whale. And you're like, whale? What you're seeing in the mirror is different from what I'm seeing in the mirror, because I'm seeing somebody who's got, you know, skin and bones. And you suspect that there may be some sort of, you know, body dysmorphia going on and some sort of, you know, not seeing clearly. Ultimately, you try to counsel her a little bit, and ultimately she loses more and more weight, and then you hear she's in the hospital, and the family calls you after she passes away, and the family says, you know, you were her trainer. You were her trainer, and she slipped away to nothing. What did you do to her? Oh, my God, I'm hiring a lawyer. So, can you be held accountable for that? Well, it may depend on your state. It may depend on whether, you know, what percentage of fault there is, either in terms of your training regimen or in terms of you not referring her to somebody who could have helped her. You tried to counsel her a little bit, but so you're a personal trainer. You're not a psychiatrist, you're not a psychologist, you're not a social worker, you're not trained to do any of those things, you're not a physician who might have been able to help her if you had taken some action to try to get her the help that she needed. So that's a scope of practice issue. Yes?
I'm sorry, you break the confidentiality agreement
Probably you do. Probably you do, but you know, in this case, hypothetically, you didn't even refer her to a medical professional. You didn't even say, listen, I think you have an issue. I'm not a doctor. This is outside the scope of my practice. I'm going to ask you now, maybe get the name of somebody. I ask you to call this person. She specializes in issues of eating disorders. I think this is what you need. And then the next time, did you call that person? And then you document each time that you make that referral. And then, God forbid, if something goes wrong and the family calls you, you say, what did I do? I'll tell you what I did. I didn't call you because I didn't, you know, I have a confidential relationship. But I sent her, on 5 separate occasions, I tried to get her to go. I gave her information. I gave her the phone number. Okay.
Can you call the physician directly if they have that person on?
Yeah, but then how would you get her to go, you know? So,
Another effort to keep the doctor.
I guess, but I'm not sure anything would really come of that, you know? I think the main thing is, you know, she would be the potential patient, and you really have to get her to go there as best you can.
Documenting on your
Yes, documenting everything that you did on your part. Yes?
What if that particular client already has someone they're seeing and you still see a negative progression? What should you do at that point?
Probably the safest thing to, to avoid any confidentiality issues would be to sit her down and say, listen, I think that you're losing too much weight. And I think I'm beginning to see and get concerned about your health issues. I would like to discuss this. I know that you're seeing Dr. Schwartz. I think Dr. Schwartz and I should talk about this and get a better handle on how we can improve your health. Is that okay if I call Dr. Schwartz? Because I want information from Dr. Schwartz, and I want to give some information to Dr. Schwartz, maybe even get her to sign something saying it's okay for you to talk to Dr. Schwartz, so you're fully covered. And then I think you've covered yourself every which way. People can sue for whatever reason, but I don't think anybody would find that unreasonable in any way, shape, or form. Let's take another kind of scope of practice hypothetical. So let's say clients say, oh, my back's been killing me. It feels so stiff. Now, you and your buddies have this little thing where in the gym, you kind of, come behind the guy and, give him a little bit of a little shake, and you feel a little crack in your back and you feel a lot better. So you say, well, let me try something with you, and you do that for the client. So obviously, what's going to happen if something goes wrong and there's an injury to the client's back? Going to be a lawsuit, right? And the lawsuit's going to be based on the idea that, okay, where's your chiropractic degree? Can you show me that? No, you went outside your scope of practice. And while I may have waived negligence in a state where you can waive that negligence, you've gone so far outside the scope of what you should have been doing that there's no waiver or release that would allow, I didn't consent to that, okay? You weren't authorized or capable of doing that. What if the client says, I feel better? Actually, that worked. That felt pretty good. Is that okay that you did that? Is that something that you should have done? Well, depending on the state, most states have, practice of medicine or chiropractic is something that is protected by license. And so that if you are practicing chiropractic in the gym on your clients without being a chiropractor, that can be a criminal offense. And the same would be true if you were practicing medicine without being a licensed doctor. So, we could look at even the terms we use, not just the activities, but the words can sometimes make it as if we're practicing medicine without a license. So, for example, if we talk about performing therapy on, how many people know that a personal trainer can't be performing therapy on a client, right? Because you're not a therapist, right? So, but that doesn't mean that you can't maybe do the activity that might be good. So if you want to say, look, I'm going to, let's try some stretches. Good way of saying something, and there's nothing wrong with doing stretches with a client, but you can't use the word therapy. I want to tell if you have sciatica, so I'm going to perform this test on you. What does that say? I want to tell if you have sciatica. Yeah, I'm now going to diagnose your medical problems. Well, you're not a doctor, and that's not something that you ought to be doing. Now, it might be, you may have sciatica, I don't know. I think you should go to a doctor. Again, let me show you some exercises to treat your sciatica. You can't diagnose, you can't treat, but you have sciatica? I know some stretches that might help you feel better. That would be okay. So, what can I do to protect myself? Obviously, we want to do that pre-training interview. We've seen what happens when that's not done. We want to have a full assessment of all the medical issues. We want to refer to a other medical professional, other health professional to obtain clearance if there's any sort of issue. And the question is, should you get a note from a doctor before you ever train any client? Most people don't. Most people don't, but obviously the safest form would be to always get a doctor's note. But certainly if there's anything that's significant, a heart issue, surgical, back problems, hip replacement, And documenting everything, the waivers, the intake forms. We talked about the issue of what happens, referring to the psychiatrist or the eating disorder. Document so that if at some point there's an issue and somebody files a lawsuit, you'll be able to get to your insurance company, and obviously you want to be insured, and say, look, here's the file, here's what I did, and they'll look at it and they'll say what you did was reasonable. So, we've talked, obviously, you're here, you're the folks that, that get the certification aspects. Having insurance, super important, different types of insurance ranging from covering negligence to covering the equipment to sexual abuse or harassment type stuff, general liability insurance. Let's say that, you have a client training in your home or, your office, and you leave your gym bag on the floor and the client doesn't see it and trips and breaks her leg. Well, that's, a different type of negligence. That's not in the training itself. That's just, general liability insurance will be able to cover that. You might have not even been in the room. So, and NSCA offers insurance as well. So, yeah, there's people doing some fun stuff, right? I don't know what this is. It's, using a leg extension machine for, some sort of hamstring, or calf rolling. I'm not sure what the purpose of that is. That's a good one. Woo, yeah. Stuff can happen in the gym, right? I gotta say though, he kind of made it look like he meant to do it, Actually, it was a nice roll there, wasn't it? Pretty impressive. So, and this I don't know how to even begin to talk about what that person is doing there, but seems to be enjoying. Yeah, I don't know. There's also the leg movement going on too. Which you're distracted by the arms, but a lot going on there, and that's just kind of like just So, all right. So, with the time that we have left, I want to just talk about nutrition. How many people are aware that giving individualized nutrition advice is something that's regulated in some states? How many are aware of that? Okay, everybody knows that. Okay, so to give you sort of a little scenario, this is your Uncle Nunzio, okay? And Uncle Nunzio likes his beer, and Uncle Nunzio likes, depending on what state you're in, that's either a hero or a hoagie or a sub, called many things, but that's what he likes to eat, right? And he says, I've had it. I look at the gut on me. I got to get rid of this thing. What can you do? You're a trainer. You're a personal trainer. How can you help me? So you say, I want to reduce your calorie intake. I want to change your macronutrient ratio. I want you to have a whey protein shake, every day. Okay. Is that legal? Yes or no? Yeah. Great. Yeah. It depends where you are. And yeah, Florida is one of the most restrictive states, So, and there you go. So it depends on whether the state you're in is what's called a scope of practice state or whether it's a title protection state. Anybody not know the difference between those two? Okay, so scope of practice, in a nutshell, scope of practice means they're protecting the activity. You can't give the advice. Title protection means you can give the advice, but you can't call yourself certain things, like calling yourself a dietitian, calling yourself a nutritionist in certain states. So, in the states that protect against scope of practice, typically the justification for it is to say, look, we want qualified people. You're a registered dietitian. You're a member of AND, the Academy of Nutrition and Dietetics, and so it's a respected thing. We don't want people who are trainers who are going to maybe tell people to eat nothing but sawdust for 4 meals a day to be able to give nutritional advice. There's drawbacks to it, obviously, because there's a lot of people who are highly qualified, extremely knowledgeable. I know people who are not registered dietitians who know far more about what to eat and proper nutrition than many registered dietitians that I know, quite frankly. But So, they're kind of shut out in states that are scope of practice states. And so whether it's really good for consumers in a age where there's an epidemic of obesity and you really want to have more people who are knowledgeable, particularly people who are credentialed or certified, giving nutrition advice or not is something that's open to debate. So in general terms, when we talk about those scope of practice states, there are states where you cannot, as a personal trainer, give any customized, individualized nutrition advice. Now, does that mean you can't write an article about nutrition? No, you can write an article. Does that mean you can't talk to a group about, listen, I think that people are too afraid of fat. Fat can be a healthy thing in the diet. You need enough fat in the diet. There are healthy fats. We're eating far too much carbs. The low-fat diet craze has in large measure contributed to the obesity in this country. A low fat typically means they've just loaded it with sugar. You can say all of those things. Now, can you, in a scope of practice state, sit somebody down, take a full assessment of them, find out what they're eating, what they're doing, and then give them a specific diet plan? Here's what I want you to do. Here's your meal plan. Here's how many calories you're going to have at each meal. Here's the amount of protein. In a straight scope of practice state, you cannot do that. And so there are states that are extremely restrictive and prevent anybody other than an RD from giving that advice. There are states where RDs and certain RDs and certain non-RDs, and it varies state by state, are shut out of the equation. So it doesn't have to be just an RD. There are other paths to licensure, but as a practical matter, personal trainers wouldn't fall within the scope of the people allowed to give that information and advice. Then there are states that enforce title protection, meaning you can't call yourself a dietitian. So you get a little business card and you say, oh, I'm going to call myself a dietitian, but you're not a registered dietitian. In those states, you're in trouble for that, even though you can give the advice. And that's a lot of states. Some states protect RDs and nutrition, so you can't even use the term nutritionist in some states, or other types of terms that are besides registered dietitian. And then there are some states that have no regulations at all, where you can call yourself a dietitian, you can call yourself a nutritionist, you can give the advice, you can write the full plan for the person, and in those few states, there's no restriction of any kind. Yes, Brad?
What if you do an online training, let's say based in New York?
Great question. Did you look at my PowerPoint? All right, so we'll get there. We'll get there just quickly. So if you're not licensed, what can you tell your Uncle Nunzio? Well, it really depends. I can tell you that in some states, even the stricter states, there are specific exemptions for family members, particularly if you don't charge the family member. There are exceptions for that. But if you charge the family member, that can, in some states, trigger the going outside and violating the scope of practice in that state. So again, these are some examples state by state of what you can do, what you can't do. And so you can check this out. There are some links. I don't know whether they'll be live links, but you can contact me, and if you're looking for links, the best source for the state-by-state breakdown is nutritionadvocacy.org. That's a website you probably want to look at if you're not sure of what exactly your state says about what you can do and can't do. That's the place that you want to look for that information. When it comes to online personal training, great question, and I wish I had a great answer for you. At this point, the internet is changing so many things about, years ago, even as a lawyer, a lawyer hung out a little shingle, and he's in Jacksonville, and the people in Jacksonville come to him with their legal problems, and he never really strayed, to Broward County. But now, there's national practices. Things have gotten a lot more expanded, and so I know that online personal training is now a big thing. So, I mean, what if you're in, let's say, Arizona, where you can say and do anything in terms of diet and nutrition, but the client is in Florida or in North Carolina, where it's an extremely limited kind of thing. And there is a case called Zippo that, in general terms, really talks about the issue of whether the conduct by talking to somebody in another state gives that state jurisdiction over you. And in large measure, it depends on how much you're doing in that other state, how aggressively you're pursuing that other state. It wouldn't be a bad idea, if you're a personal trainer in Arizona, to write into your contract with your client that, you know, I'm an Arizona personal trainer, and our relationship is subject to the laws of Arizona. It is occurring here in Arizona. You've contacted me. I'm in Arizona. You know I'm in Arizona. And so that, you know, would offer some protection. Obviously, if you're in Arizona and you're marketing in North Carolina or Florida, in some way maybe doing an email blast to all to potential clients in Florida, I would see that the court might go the other way in looking at where that behavior, where that conduct takes place. Yes?
Yeah, in Florida, under Florida state statute, they have to be associated
With RD in Florida. Yeah, and you can kind of see where this all comes from. You know, I mean, whether it's really to the benefit of the consumers or whether this is a trade union that's really looking for protection, I think we get it. So the last thing I want to just talk about, we've got maybe another minute or so. How many people here counsel drug-tested athletes? Athletes who are either NCAA athletes or, okay. So just a few of you, so I won't go into that in too much detail. Obviously, there's issues in terms of contamination of dietary supplements, and we've seen that happen. So if you're a trainer and you've got a client who is maybe an Olympic hopeful or who is a college athlete, the question becomes, what do you tell that client about taking supplements? And what do you tell that client about taking any other sorts of stuff? Well, I think it's important to let the client know that supplements can cause positives, and I've represented lots of athletes. You know, not too long ago, I represented the #1 ranked middleweight boxer in the world, Sam Solomon, who tested positive because he took a dietary supplement product. So making sure that you do not tell them, I'm telling you to take this product, because that puts the liability on you for that. In terms of steroids, how many people know what that is? There you go. Okay, so you know, I don't know why guys are doing this. The telltale is the tiny forearm, because they can't inject the forearms, so all the oil is in the upper body, upper part of the arm. So you know, we can talk about what to tell clients in terms of performance-enhancing drugs. If you want more information on that, steroidlaw.com is a great place to go. Supplement Council is the site for any kind of information on dietary supplements. If you haven't seen Bigger, Stronger, Faster, I do recommend that you go to Netflix. You can pick it up. It's a great movie about what performance is in American law, culture, and politics and sports. Anybody who wants to get in touch with me, I'm easy enough to get in touch with. You can go to my websites, or you can call me right at that number there. I appreciate the opportunity to talk with you. I'll be outside for a couple of minutes if you have any questions. So thank you very much, and enjoy the rest of the conference.